Hello, my name is Mason Waring. I'm an attorney and partner at Chisholm in Kilpatrick. I'm joined here today with my colleague, attorney Leah Small. We represent people in their long-term disability insurance claims with insurance companies. These are people who received coverage through their employment, or they bought insurance policies directly from the insurance company. They're disabled, they filed a claim, or their claim's been denied, they need to file an appeal, or they need to go to court, and we help them through that process. Today, we're going to talk about an important subject, deadlines. We get a lot of questions about deadlines. Deadlines to file the claim when you're disabled, deadlines to file an appeal if you filed a claim and your claim was denied, and then deadlines when it's time to go to court. When you're done with the administrative process with the insurance company, the next phase, if your benefits are denied, are to file a lawsuit in court. So we're going to answer some of the basic questions here. Spoiler alert, the answer to a lot of these are read your policy, read the plan documents, understand the law in your jurisdiction. There aren't many cookie cutter responses to these questions because it's going to depend on how your policy is written, how the plan's written, and where you're located in the country. But there are some important considerations that we're going to hit here that should give you some guidance and maybe direct you where to look to understand some of those. And this will give you should give you a good mental model of the deadline framework here with the long-term disability claims. So let's get started with the beginning. Leah, could you start us off by talking about deadlines to file the initial claim?
Sure. And as you mentioned earlier, there is no one deadline that applies to all claimants for filing an initial LTD claim. So it can vary from LTD plan to LTD plan. So as you said, if you need to file an LTD claim, you should request a copy of your plan governing documents from your employer, or more specifically the HR department often, and read these carefully. These documents will explain what your coverage is, your benefit amounts, and importantly, what the deadlines are for sending notice of claim to the insurance company, so letting them know that you're disabled and need to file a claim, as well as the deadlines for filing proof of claim or evidence of your disability with the insurance company. And it's really important that you read these carefully because it's possible that if you miss these deadlines, you might lose your rights to these benefits.
It's tricky sometimes when people are working while they're disabled, or they're no longer able to work, but they feel like they don't have time to file the claim. It could be a tricky situation because maybe you're really focused on your health. You don't want to wait too long. I mean, there are maybe instances where you want to wait for a test to come back, or you're really going to attend to your health, but time is not on your side here, and you want to get that claim filed when you're ready, but as soon as you reasonably can, particularly if you don't think you have all of the policy or plan documents to fully understand things. Depending on your jurisdiction, there can be some really harsh consequences to not meeting the deadline that you're required to meet. So that's, sorry, Leah, go ahead.
I was just going to add, we often see that a lot, especially with people who are planning to go back to work. So they're unable to work now, but they plan to go back to work. So a lot of times, our clients will say, oh, I didn't want to file the claim because I was planning to go back. But then they're facing an issue down the line where they're not able to return, and now they're late filing the claim, and they're facing potential loss of benefits or other results.
That's a good point, and it's something we commonly say: don't let your goals get in the way of reality today. And so many people, obviously, if you're not feeling well, there are many conditions where it could render you disabled for a period of time, but maybe at some point in the future you'll be able to go back to your same or different work. And that's a great and important goal to work towards. But if you are disabled today, get that claim in because you may be entitled to benefits for a limited period of time. And if you wait until you know whether or not you'll be able to go back to work, that could be too late to file that claim for the initial period. So just really, time is not on your side with these claims. You want to be deliberate about it and make sure you understand your rights, but don't delay or hesitate in making that claim. And if you have questions, these can be tricky issues, talk to an experienced long-term disability lawyer. We advise people in this position all the time. So people will reach out to us if they are working or newly gone out of work and are contemplating making a claim. We help them get the documents that need to be reviewed, review them, and can counsel them based on their individual circumstances. And that can be really helpful in making or doing some life planning and settling out what your at least immediate future looks like while you're trying to take care of your health. So it costs nothing to reach out to us to see if we can help. So please don't hesitate to do so. Moving on to timeframes for appeals. So now you've filed your initial claim, assume your claim gets denied. Then you need to engage in administrative appeal process with the insurance company, particularly with an ERISA governed plan. Leah, tell us what those deadlines are.
Sure. So under ERISA, which is the federal law that governs most of these employer-provided long-term disability plans, the insurance company has, or a plan administrator or claim administrator, has to allow you at least 180 days to appeal a claim denial or benefit termination. Now, again, your plan documents potentially could provide for a longer time period, so it's important to read those. But again, you have to be allowed at least 180 days. And it's critical that you meet that deadline, because if you don't, again, you could lose out your rights to these benefits. And with that, it's not enough to just say, I appeal by that deadline usually. Normally, you also have to get in all the evidence in support of your appeal that you want the insurance company to consider by that deadline as well.
And the 180 days is pretty common, pretty standard, but there are absolutely exceptions to that. And particularly like in the life insurance context or health insurance context, and even the disability context, you need to be aware of shorter deadlines. And many professionals will have received long-term disability coverage through their employer and maybe have purchased their own insurance policy, sometimes from the same insurance company that the employer uses to provide the long-term disability coverage. There could be different deadlines for filing claims and appeals on those different policies. So you always, again, reemphasizing, you need to get those documents, the policy documents, the plan documents, and read them carefully to understand what your deadlines are, because it could be less than 180 days. And Leo, what's the consequence again for failing to file an appeal on time in an ERISA governed claim?
If you miss that appeal deadline, that often is the end of your LTD claim, and you will lose out on your rights to those benefits, no matter how disabled you might be.
So it's critical to file your appeals on time. There are instances where you may need an extension to file an appeal. I would make sure that your extension is in writing, confirmed by the insurance company if you did get one. And you really need to deal with those carefully. If you're in that kind of situation, that's a great time to consult with a lawyer. Really the appeal time, filing that appeal, it's really important to consult with an attorney and try to get one involved on your behalf. For many people, it's often the last opportunity you'll have to get substantive evidence into the record. So in addition to having a really important deadlines you need to make with respect to the appeal, you also need to make sure you've gotten your evidence in that you need to go to court if you need to do that. So moving next to court. So let's assume you file your administrative appeal and that is denied. The next step is often court. Some insurance companies will offer a second level appeal. Some ERISA plans will as well. But you should assume that you get one appeal. You might get more. Again, read your plan documents, read your policy to see what it provides. But let's assume you've exhausted your appeals. It's time to go to court. Leah, how long do people have?
Again, there's no one-size-fits-all rule here. It can vary LC plan to LC plan and claim to claim. Many long-term disability plans contain a deadline for filing a lawsuit under that plan, and we call this the contractual limitation period. So again, review your plan governing documents carefully to see if your employer's LTD plan has such a deadline. Because as with all the other deadlines we've discussed, if you fail to file the lawsuit in court by that deadline, you can lose your rights to your benefits. For ERISA governed claims that were filed after April 1st of 2018, if the insurance company denies your appeal, in that denial letter, they need to include the calendar date on which that contractual limitation period expires. So the insurance company should tell you if you filed your claim, this is after April 1st, 2018, but again, it's best to review your plan governing documents and review that deadline for yourself to make sure you're meeting that deadline. And if some LTV plans don't have that contractual limitation period in them though, in those cases, generally the deadline to file a lawsuit is governed by state law and the statute of limitations in that state. But again, that varies state to state. So you have to know the law governing what state you're in, or potentially your LT plan could say X state law applies, and then you might be dealing with that state's law. So again, this can be complicated. You need to review your documents carefully, make sure you understand what laws apply. And this is an especially critical time to get a lawyer involved to make sure you meet these deadlines, because whether it's a contractual limitation period or the state statute of limitations, if you miss it, again, you could completely lose out to your benefits.
And hopefully by this time, hopefully you got a lawyer involved during the appeal process. And so when we're handling an appeal for a client, if the appeal is denied, it's time to go to court. We sort all this out for our clients and advise them on the recommended course of action. It's not always a clear answer what state law applies and what statute of limitation applies and or how the contractual limitation will apply. So there's often a degree of judgment that we need to exercise, and we do that for our clients to sort through these issues for you. Leah, what else, if anything, do we have to tell our viewers about deadlines today?
So once the appeal is submitted to the insurance company, they have 45 days to make a decision. However, they are allowed to take a 45-day extension if there are special circumstances that justify additional time to process the appeal. Like with initial claims, they have to send you written notice of the extension, and that letter has to explain what the special circumstances are and identify the date by which they expect to be able to make a decision on the appeal. Again, if the insurance company requires the extension because you failed to provide information to them necessary for them to decide the appeal, then the time period is told or paused until they receive that information from you. And unfortunately, even with these requirements around taking extensions, it's not uncommon for insurance companies to assert that there are special circumstances requiring this additional time or extension, when really they just haven't reviewed the appeal in a timely manner. So this is another instance where having a lawyer involved can be really beneficial, because we're experienced keeping an eye out for that and holding the insurance company to the requirement that there actually be special circumstances before they can just take an extension.
Yeah, that's a great point. We track your deadlines. We do everything we can to get the evidence that the insurance company requires of you to the insurance company as soon as possible, to eliminate those excuses of, hey, I'm waiting for you, claimant, to provide me with information. We don't rest and wait for the insurance company to do the data collection. We do it for you and submit packages with proof of what we sent, when we sent it, so we can hold them accountable to deadlines. Leah, is there anything else to add about deadlines today?
I think just one more time, deadlines are critical, and if you don't meet them, you can be putting your benefits at risk. So make sure you read your long-term disability policy or plan governing documents and make sure you're meeting all applicable deadlines.
Yeah, it can get complicated and really feel overwhelming. It really underscores why it's important to get an experienced long-term disability lawyer involved in your case. That's what we do. We're dedicated to that mission, to helping people make these claims and deal with the complexities of these cases. So if you have a claim pending, you're thinking about making a claim, you need to make an appeal, feel free to reach out to us. We'd be happy to speak with you and see if we can assist. It costs nothing to see if we can assist. Leah, thank you very much for all that great information today, and I hope you all have a great day.